Hello everyone, I'm Ankit. You're watching Study IQ IAS English. Now you have to understand that there have been many people like Vijay Mallya, people like Nirav Modi, people like Mehul Choksi. They took a lot of loans from Indian banks and failed to return them back. Essentially, they committed a crime in India. And in order to evade the law enforcement authorities, they ran away from India and never returned back. Now, India has one judicial recourse using which they can bring them back to justice. And this process formally is called as extradition process. So what does the word extradition means? How this extradition process works? What are the technicalities behind it? Everything we are going to cover in our today's session. Now, if you want to download the notes that I will be utilizing in this session, you can go to a particular Telegram channel known as ATS Live and download the notes. And while you're at it, just please remember to hit the subscribe button as well. Okay, so let us start our today's discussion by understanding the context of what is happening and why are we discussing this legal recourse. Now, over the years, India has sought to extradite several fugitives, including Nirav Modi, who has been co-accused in the PNB scam, and liquor baron Vijay Mallya. But the record of Indian government being able to bring them back to justice in India has been somewhat mixed. There have been cases, but one or two cases where some criminals have been extradited back to India. Now, 4 months after Mehul Choksi was arrested in Belgium, the Indian government has sent a formal request to the Belgian government that it is going to, or it is wanting the Belgian government to extradite Mehul Choksi back to India. And because of this, the letter of assurances has been given to Belgian government, using which has highlighted the conditions in which this person would be jailed in India and what would happen to him in case he's extradited back. So basically, Indian government has started or initiated the formal process of extradition with the Belgian government to bring back Mehul Choksi. Now, in this regard, there have been questions in the UPSC prelim that deals directly with the fundamental rights of people. For example, right to privacy. Now, you need to understand whichever person, Indian citizen or foreign citizen, whenever he or she commits a crime in India, they are subjected to Indian laws and land. But in addition to that, they also get a right, that is a right to free trial. So in that regard, we'll understand right to free trial becomes a part of which article. Okay, so that question we'll deal with before the end of our today's session. Let us get away with the process of what is known as extradition. Now, extradition is a formal or a legal process using which the one country hands over another country the person who has been accused or convicted of crimes. Now, it is meant to ensure that no person can evade law just by merely crossing the borders and getting into another country, right? For example, Indian laws, they are applicable inside India. They are not applicable in countries like Belgium and UK. So for any person to be tried, to be committed to a crime which they have committed in India, they have to bring back to India. And this process formally is called as an extradition process. Now, what happens in this extradition process, that this in India is governed by a particular act of parliament, Extradition Act 1962, which gives a definition of what is an offense that constitutes an extradition offenses. For example, if India has entered into a formal agreement with another country, that is a formal extradition agreement, in that agreement there would be mentioning of different crimes that can be committed which would make a person liable to be extradited back to India, right? Similarly, India does not have treaties with each and every country in the world. So there is a possibility that a person who might have committed crime in India, they went back to another country with which India does not have a formal extradition treaty. So in that regard, it covers offenses which are punishable for at least 1 year of imprisonment under the laws of India or for foreign laws. And this also includes composite offenses which are committed in the one part of the country and its effect are felt on another part or different country. For example, terrorist activities. Now, India and Pakistan does not have a formal extradition treaty, but suppose a terrorist from Pakistan commits a terrorist activity or monitors a terrorist activity in India, he has committed a crime which has affected Indian soil. So that is also a ground or a liable ground using which India can demand extradition of terrorists from Pakistan. Not that it will ever happen, right? So this is how the Extradition Act of 1962 determines what are the offenses liable of which a person would be extradited back to India. Now, according to the website of Ministry of External Affairs, it says that India has a formal extradition agreement with as much as 48 countries, and it has a sort of an arrangement, although not a formal treaty, with more than 12 countries. So in total, India has an extradition arrangement or a treaty with as much as 60 countries. But you need to understand, world has more than 60 countries, right? So this is what is regarding to extradition treaty that India has. Now, how this extradition process works in India, let us understand this. Now, suppose if India wants to extradite a person located in foreign country. So India, being one state, would send a formal extradition request through diplomatic channels or through whatever channel is mentioned in that agreement to the another country. Now, this would include normally the description of the fugitive, what are the crimes he or she might have committed, or the maximum punishment on which the crimes they have committed is liable to get in Indian laws. Similarly, if this person has already been convicted by Indian courts, then the government of India would also attach a copy of judgment with this formal request of extradition. So this is how government of India can request an extradition process with another country. Similarly, they can also initiate a process with Indian government. Now, second part comes the judicial scrutiny. What if India receives a request from foreign country, then what happens? Now, what happens once you receive a request by the central government? This is referred to a judicial magistrate, and this judicial magistrate issues warrants, examines the evidence that is provided by another country, and then conducts its own inquiry. If they find this is no case, then the fugitive is released. But if the magistrate found that there is a prima facie criminal case on this person, this fugitive is put into prison and the report is sent to the government that they can formally initiate the process of the judicial extradition. Now, what you need to understand, although this is a legal process, but who is the final decision making authority? It rests with central government in India. Similarly, with other countries also, it rests with their respective governments. So this is less of a judicial process, more of a political process. In theory, a person has to commit a crime before they can be extradited, but in reality, not every criminal is extradited back to our country, or they are not extradited away from India, because this is more of a political decision, right? So this is what the extradition process and how it works in India. Now, what you need to understand, there are certain safeguards attached to this extradition process. First is, what if the fugitive is not extradited within the 2 months when the court has ordered for his extradition? So in that case, the fugitive can approach High Court in India for release, and it is at the court's discretion whether they want to release the convict or not. Second part is known as principle of speciality. Now, this principle of speciality is only when a person can be tried for an offense using which the extradition was guaranteed, right? So suppose if a person is being trying for a murder offense, you can't try that person for another offense, say money laundering, because you have agreed to conduct his extradition on the request of an offense which was formally made by the government, right? So this is known as principle of speciality. Similarly, there is another third event where the extradition has certain safeguards. It is known as the evidence that emerges from abroad. Now, many fugitives in India or also in abroad, they can actually challenge the quality of the evidence or the applicability of the evidence in the process of extradition, and then the courts need to properly authenticate whether the evidences provided against the extradition request is correct or not, right? So these are the safeguards that have been attached. Okay. Now, what you need to understand, whether India does not have a treaty with another country, does it mean that extradition won't happen? The answer is no. Extradition can still happen, which means that in case of absence of treaty, it does not mean there is an absolute bar on extradition. It is somewhat rare, but it is possible. Now, what happens if you read the Extradition Act 1962, particularly Section 3 of this Act, you'll remember that central government of India is a member of many international conventions like UN Convention on Corruption, UN Convention on Organized Crime. Now, Indian government can conduct extradition or can do extradition even with a country with which they have signed these international conventions. So suppose India can ask for extradition from Pakistan because both Pakistan or India, they might be member to this single international convention, right? So in case if you don't have a formal extradition agreement, still it is not a bar on extradition. You can still get extradition just because the respective two countries are members of different international conventions. Also, there is what is called as reciprocity principle. Now, some states, they extradite without treaty under domestic law just because they want to get favors with another government, right? And therefore, I told you this is more of a political process. So, although this process is somewhat rare, but that does not mean it is not possible. It is possible depending upon the various checks and benefits or cost benefit done by the countries. There is also another alternative. This alternative is called as deportation under immigration laws, or what if that person is on trial in host country. So in that case also any criminals can be extradited back, but this won't be called as extradition, this will be called as deportation, right? So these are the cases where extradition can even happen without a formal extradition treaty. Now, there are some grounds using which a country can refuse for extradition, and this was in news when government of Bangladesh wanted Indian government to extradite the former PM of Bangladesh, Sheikh Hasina, back to Bangladesh. So, what are the grounds in which a government can rightfully reject the extradition request? This is called as offences of political and military character. So, whenever government of Bangladesh made this request of extraditing Sheikh Hasina, it was assumed that the charges that were committed on her were political in nature. So, government of India was an official ground to reject the extradition request of Sheikh Hasina. Similarly, there is a limitation period in requesting country. So, suppose the extradition request want you to send a criminal who might have committed a crime 25 years back. But there are different kind of laws which prohibit trial after a certain period. So suppose if an extradition request demands that a person conducted crimes 25 years back, and if your local law says that this person can't be tried after 15 years if they have committed a crime, this is a limitation period, and this case also the government can formally refer or reject the extradition request. Third condition is what if the fugitive is already facing trial and serving sentences in India. So in that case, Indian government would say they are already serving in the jail, so we can't extradite them back to you. Also, if the request from the country or the origin country's discriminatory nature based on the race, religion, nationality, or even of political opinion of the person, this is also a formal ground of rejection of request. We have seen in many cases, especially in authoritative countries, where people having different opinions than the ruling dispensation, they are prosecuted, and to escape prosecution they often move back to another country. So in that case also, if the request itself is discriminatory, the government can request or reject the extradition process. Now, if requesting state, they cannot ensure compliance with the principle of speciality, which means that the speciality principle, which we have already covered, that this principle can only be tried if the offences of the extradition was granted. So this speciality principle, if the host country can't deny this, then also the request of extradition can be rejected. So suppose if a person is extradited back for terrorist activities, now the host country would only be allowed to extradite that person in case if they want to conduct a trial for terrorist activities. But what if the government decides to conduct a trial for money laundering? What if government tries to conduct a trial for different offences? In that case, if the countries can't guarantee them, then it is not allowed. Also, there are several human rights concerns. What if the person would be jailed in another country, not in so good conditions? The treatment of the prisoners in this country might be bad. In this case also, the extradition can be rejected. So therefore, you can understand why is government of India highlighting the conditions on which Mehul Choksi would be kept in India, just to fulfill that this human rights concern does not emerge as a roadblock in extradition process, right? So these are the grounds based on which there can be a formal refusal of extradition process. Now, what is the challenges in extradition process? We understand this is a formal process, but this is not something that happens quite frequently. It is of a rare occurrence. So what are the challenges that we also have to know? First challenge is known as dual criminality requirement. Now, an extradition can only happen if a person has committed a crime here and that similar crime is there in the host country. So suppose if you have taken a loan in from Indian banks and if not returned back the loans, then you will only be extradited if this is a criminal offense even in Belgium, right? Similarly, if someone has committed triple talaq in India, which is an criminal offense in India, and he moves back to a country where triple talaq is not a criminal offense, then that person can't be extradited back to India because of absence of dual criminality. Understood this logic? Similarly, there is another factor known as evidence standards. Now, foreign courts often demand strong evidences which is acceptable in their legal systems, and often you'll see many Indian criminals living abroad, they challenge this extradition request based on the fact that the evidences provided are not strong enough. They are circumstantial in nature, right? Third factor is human rights issues. Many prisoners or many criminals, they often take recourse of this just because they highlight the prison conditions is not sufficient. The death penalty or the trial reassurances the government can't assure them, so please do not extradite us back to India. Similarly, the cases attached to political sensitivities. Now, the problem with these people, Mehul Choksi, Vijay Mallya, they are rich people. They have committed a crime, rightly so, and they should be extradited. But when you're rich, you utilize this power to negatively influence the foreign government, and this we have seen in case of Vijay Mallya. Government of India formally requested the extradition and he was held guilty by all the courts in UK. But still the process of extradition has not been approved by the UK government. How do you think so it happened? Just because of the negative use of influence. So these are the challenges in real life that happens, which can create roadblock and indeed create roadblocks for the process of extradition. Understood? Now, before solving this question, I have something I wanted to tell you. We are in the month of September and the next year the exam is on May. You still have time. You still have time to clear this exam provided you get the right guidance. And this right guidance would come to you only when you take the Resolution Plus batches. Now we have another batch which is starting on 20th of September. So you can take admissions and we'll see each other in the economy classes from 20th of September. Now the rates at which you can take admission is this, but you'll get this discounted rate only when you apply the code ATS Live, which will get you discounts not on just this 2026 course, but on all the courses available on our website. On GS Foundation course for 2027, 2028 for optional, for judiciary, for state PCS, whatever you want, you'll get the discounts and maximum discounts using this code. Okay. Now there is a practice question similar to the question that I gave you in the beginning of this session. Right to free trial is recognized as an essential facet in the principles of natural justice. Which one of the following in the Constitution of India correctly and appropriately implies the above statement? Do let me know which is the correct answer to this question in the comment section, and the ones who answer it correctly will get a thumbs up from my side so that you know you've done it right. And once again, if you want to download the notes, these will be available on this Telegram channel known as ATS Live. So go to this channel, subscribe to it if you still haven't, and download the notes. Okay, so we'll see each other again. Please have a very good day.